Coming up on this program,
Money
we
Mart
show
moves
you how to
from
get
a fancy
connected.
price tag.
Find out how to
Hello everybody, I hope everybody is doing well tonight. Earbuds in, Julie says. Check. Other screen muted. Check. Guys in the truck. No check. We don't have them today. I hope everybody's doing well though. I love to see you here. If you are just getting here, make sure that you like the video and tell me what you have for dinner. If you didn't like what you had for dinner, tell me what you wish you had for dinner. As many of you know, I am a personal chef to an asshole in his 40s. And lucky for me, he is on a absolutely boring diet as of lately, so my chef duties are barely needed. However, I did cook his chicken and rice ration. He is not my husband. No, there's no joke there. He is an asshole in his 40s who I am a personal chef for. And he is on a strict rice and chicken and broccoli diet. Normally I am given free reign to determine his meals, 3 a day, plus snacks, but as of late he is doing this along with Ozempic, making me feel just a whole lot of lonely cooking, because I cook in bulk for him and then meal prep it, and then I just cook for myself when I feel like eating. But the good news is I already went to the gym today. That's right, I went last night and this morning. What? Woo! And I am glad. But he, yeah, it is my ex-boyfriend. We used to date. We don't anymore, but we live together in a cruel twist of fate. It really is a bit of a cruel twist of fate. But the good news is that I am setting new, I don't know, what do you call them? Routines. That's what you call them. Hi, Christopher Engleby. Over the last year, I have made it a routine to come here and hang out with you guys, watch court, and I do it every single day. Keeps me on track and out of trouble. And we're going to go to the gym. Probably not every single day, but we're going to the gym. We've been for the last 5 days. And, Julie, he has in some senses tried. That's part of me living here. I do the cooking. In fact, and I'm joking, but it's actually, he's exceedingly easy right now to cook for. But it's funny whenever, because I love cooking and I love baking, but when you have, my arms look like guns. I know I have big arms, Cindy. No, but when I, make like baked goods or items, he'll taste it and he'll be like, "You're trying to make me fat?" I'm like, "No, absolutely not." But we all know where flavor comes from, don't we? He watches the Food Network. He'll call me in from the couch. He'll say, "Hey, Paisley." Actually, that's not what he calls me, but I won't repeat it. Oh, Chris. Thank you so much. Oh my gosh. Members only. Shane, you got a membership. Anyways, he calls me in and he'll say something like, "Look what that guy's cooking." I'm like, "Look at that guy's kitchen. That guy's in a fucking Food Network kitchen." Okay? I can cook some of these things, but also ingredients. Always surprised at how much food costs. I'm like, yeah, you want that? I can make that, but it costs a lot of money to make a lot of these things on the Food Network. The Food Network is not relatable. Let's just say that. Anyways, I hope everybody's doing well, though. Like I said, well, maybe I didn't say, we're watching some court today from Judge Kirkham's court. Oh, yeah, I didn't say this, but I had to juggle because there was a long. Oh, Ed, thank you for that question. The microwave is hung, the stove has been switched, but the old stove is still in the kitchen. See, I will take my own grumbles. Okay, I am not the most organized in certain things, but that has been there for how long? A long time now. Now we have two stoves, one that doesn't work, one that does. Whatever. I don't push my luck. At least I have a working oven that's huge. It feels huge. It feels too big because I've been cooking out of an air fryer and a miniature oven. Anyways, Kirkham had a really long case today. It's a grandparents' right case, and I think that we'll watch that tomorrow and this weekend over the next 3 days. But because it's like 6 hours or something like that. But for tonight, we have some child support court cases. Oh, look, Shane said thank you to Christopher. I love the circle of life of memberships. Thank you, Christopher Engleby. Okay. Oh, I gotta put on the video. Oh my god. I'm so embarrassed. You guys should have seen what I looked like 6 minutes ago. Because I barbecued all the chicken, which is great. Oh no, is this the right one? Nope, it's not. It's not the right one. There we go. Bingo, bango, jingo, jango. I wanted bacon today, but I settled for... Oh, and I successfully fasted again. Either I'm good at it, or what I think is that I've had unhealthy eating habits my whole life, and fasting actually strokes right through unhealthy eating at a weird cross section. So I'm always like, I'm done. But so it's making me eat a little bit healthier. Come on, state of Michigan. Like, we have some patients, but not a lot of patients.
Confinement.
Okay, there we go.
For you.
Anyways. Oh, I turned off my not dead filter as well. In case anybody is wondering. Aww. You're so sweet. Thank you, NPC. Skippy is peanut butter too, right?
Hey, just a moment.
She looks. I say this every time, but doesn't she look like she's about to give a psychic reading? I know she's not. I know she works for the court. All the respect to Sonia, but I just think it is everything I would expect from a psychic reading online. Everything I would want in a background. It's just, you know, when nobody these days does a background, she's done a background. All right, let's continue.
The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. It is Wednesday, September 18, 2024 at 10:02 a.m.
Good morning, Judge. I can't hear you. Can you hear me?
Oh, your audio is messed up, Judge. So garbled. Yeah, try to join Zoom again.
Is this the judge zooming in from his vacation? Something was different this week, if you notice. He's not in the courtroom. I think he's zooming in from his dive lesson in the Bahamas. Ladies and gentlemen, that he won on his last game show appearance. No. Obviously, I'm glad to hear that, John.
Well, hopefully this is
Oh,
better.
yes.
Is that better?
A little bit, Judge.
Okay, good. Well, Ms. Brown, go ahead whenever you're ready.
Thank you, Your Honor. Docket 2014-3544DS. The respondent is Joshua Cooley. I did speak with Mr. Cooley this morning. He is employed. Income withholding payments are coming in. So friend of the court is asking that we dismiss this matter.
Dismissal's granted.
Thank you. Docket 2020-1096 UN. The respondent is Adriana Christian. I did speak to Ms. Christian this morning. She's waived her right to a hearing today. She has a pending Social Security claim. Friend of the court is asking that we adjourn the matter till December 18th at 8:45 a.m. to monitor that claim and to allow Ms. Christian the opportunity to request a modification.
Okay. Court would adjourn the matter to December 18, 2024 at 8:45 a.m. to allow Ms. Christian to pursue her Social Security claim and any modification.
Folks, if that is not a reminder to you to get your fucking shit together for Christmas, there you have it. The first of our December hearing settings that I've heard. Please don't wait till the last minute.
Thank you. And lastly, docket 2022-3037DS. The respondent is Trenton Clifton. Mr. Clifton has failed to call in this morning for his hearing. However, this case is only charging for confinement. The parties have reconciled. We did issue an income withholding on September 5th to his employer. So friend of the court is asking that we adjourn this matter until October 30th at 8:45 a.m. to allow time for the income withholding payments to start.
Court will adjourn the matter to October 30, 2024 at 8:45 a.m.
Thank you. That's all I have.
Okay, thank you. Have a great day.
You too. Bye, Jesus.
Bye. Take care, Sonny. All right, next.
Where is the judge? If not in the Bahamas, where is he? At his lake.
Good morning, Ms.
house.
Mouton.
Good morning, Your Honor. How are you today?
I'm doing well. You?
I'm well, thank you.
Okay, go ahead when you're ready.
Okay, just have a few for the record. Docket 2013-1.
We have to talk about something. I've never seen anybody do this. I'm really hoping that her client's name is Black because she's identified her pronoun and I think her race. Oh, please, please, please. Is that normal? Oh my. Okay. Here we go.
1028DS, Wright versus Sackgen. The respondent, Christopher Sackgen, just phoned in this morning and spoke with friend of the court, and he waived his right to appear. He is working, and friend of the court is in the process of sending out an income withholding order. So friend of the court is requesting that the $600 bond that he posted on September 6th be forfeited, that he be ordered to pay his order beginning October 2024, and that the matter be adjourned until November 6, 2024 at 8:00 a.m. to monitor that income withholding is established.
Court would forfeit the bond previously posted by Mr. Sackgen, would order that he comply with all orders of the court and will adjourn the matter to November 6, 2024 at 8:00 a.m.
Thank you. Docket 2015-2634DS, Goodwin versus Atten. Friend of the court spoke with Jason Atten this morning, and he waived his right to appear before the court. He is currently enrolled and participating actively in the GEMS program. So friend of the court is requesting that he be ordered to make a $100 lump sum payment by September 27, 2024. And this matter be adjourned until November 6, 2024 at 8:00 a.m. to allow him to continue to participate in GEMS and to gain employment.
Court would order that Mr. Atten would pay a lump sum payment of $100 no later than September 27, 2024. We'll adjourn the matter till November 6, 2024 at 8:00 a.m. And order that Mr. Atten would continue to participate in the GEMS program.
Thank you. And then I have.
That was a slip up. I think he's on the West Coast 2 hours earlier. He mistook and said his secret vacation time instead of the other time. Obviously, this is a joke. And I do hope this lady feels better. I hope I can't get sick through the computer. I know that sounds fucking stupid. But I don't want it. I don't want it. She sounds like she should not be at work. Let's put it that way. Send her home with pay. 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 I'm Canadian. No sick from the computer. And no sick from work. Get back to work, Americans. I'm just joking. Hi, American courts. And I love all my American friends. I joke. I joke. A little.
Dockets 2009-2996 DP, Langston versus Adam. Docket 2012-2869 DP, Carlson versus Adam. And docket 2019-3659 DS, Patterson versus Adam. And all of these matters, the respondent Keon Adam failed to appear for an adjourned compliance hearing, and he has failed to comply. Friend of the court would request that bench warrants be issued and that bond be set pursuant to statute.
Court would order bench warrants for Mr. Adams as a result of his failure to appear on today's date. The court would set his bond in the amount of 25% of the outstanding arrears or $500, whichever is greater.
Thank you, Your Honor. That's all I have today.
Thank you. You have a great day.
Thank you too.
Good morning.
Good morning, Ms. Gilman. How are you?
I'm good. How are you?
Good. Proceed when you're ready.
All right. Thank you. The following respondents have waived their right to hearings. First is docket 2007-4381 DM regarding Peggy Minshaw. They failed to call in, but we have been advised of a possible custody change. Friend of the court is requesting to adjourn the matter 30 days to gather proper documentation regarding the custody change.
Court would adjourn the matter 30 days.
Thank you. Next is docket 2023-2732 DS regarding Andrew Palacio. They've been meeting their monthly obligation. Friend of the court is requesting the matter be dismissed and they continue to pay as ordered.
Court would order that Mr. Palacio would pay as ordered and will dismiss the action.
Thank you. And finally, we have dockets 1988-1889 DP, 1991-1160 DP, and 2014-1173 DP regarding Michael McGee.
Michael McGee, 1988. That's my year, baby. What the fuck case do you have open from 1988, sir? I'm 36 years old. You're paying child support arrearage on a 36-year-old? Oh my god. Also, yeah, I'm drinking Coke. I'm also eating bread. But I am working out. I know, sometimes I work against myself, but I can't change it all at once. Anyways, oh my god. 1988? Well, did she say that? She did, right?
The child support aspect of the 1988 case has been paid off, and they've been meeting their obligation for the 1991 and 2014 cases. Friend of the court is requesting the matters be dismissed and they continue to pay as ordered.
Court would dismiss the actions.
Thank you very much, and that is all.
Okay, thank you. Have a good day.
You as well.
The big D, we're getting so many D's tonight. I love it. Who'd have thought Thursday night would get the D up the a-hole? Oh, sir, you're so sad. Turn your frown
Good morning,
upside
Mr.
down.
Clan. How are you? Oh, you're muted.
Tried to fix that. I'm
Okay.
doing well. How are you today?
I'm doing well. You can proceed when you're ready.
Okay, thank you. The following cases were scheduled for enforcement hearings today, and the respondents have waived their right to a hearing. I have 2010-3136 DC. Respondent Michelle Hines appeared from Calhoun County Jail. A friend of the court is requesting respondent report to the FOC within 14 days of release. They participate in the GEMS program, requesting dismissal, the bond be canceled, and the respondent be released forthwith.
Court would cancel the bond previously ordered for Ms. Hines, would order that she be allowed to be released from jail, that she would report to the front of the court within 14 days of her release from incarceration, that she would participate in the GEMS program, and will dismiss the action.
Thank you. 2017-1524 DS. Respondent Hoyt is making payments on their own as in substantial compliance. Friend of the court is requesting a dismissal, and respondent pay as ordered beginning 10/1/2024.
Court would order that Mr. Hoyt would comply with the orders of the court and dismiss the action.
Thank you. The following case was scheduled today for an enforcement hearing, and the respondent failed to appear and failed to comply. 2022-1662 DC. Roman Ibarra, FOC, is requesting that a bench warrant be issued and bond be set per statute.
Court would enter a bench warrant for Mr. Abada. As a result of his failure to appear on today's date, the court would set his bond in the amount of 25% of the outstanding arrears, or $500, whichever is greater.
Thank you very much. That's all I have for today, Don.
Thank you. Have a good day.
You too. Thank you.
I want to get my nails done, cellulite yoga pants. Don't remind me. I'm terrible at doing nails. I don't think it would be worth it to learn. You're just
Good
never
morning,
good
Ms.
at doing your
Platic.
opposite nail.
You're muted.
I'm not muted.
Good morning, Judge. How are you today?
I'm doing great. You?
Not too bad.
Good.
Quite a few matters for the record and then a couple of hearings for you.
Okay.
Start with docket 2014-3573 DS involving Brandon Brown. Friend of the court spoke with Brandon Brown and his right to hearing was waived, requesting that this matter be adjourned approximately 60 days to allow his new income withholding to take effect, and he pay as ordered beginning September.
Court would order that Mr. Brown would pay as ordered, and will adjourn the matter 60 days to, again, allow the income withholding to take effect.
Thank you. Dockets 2015-2404 DS and 2018-741 DZ. Both of those involve Cody Babcock. Friend of the court met with Mr. Babcock this morning, and his right to hearing was waived, requesting that both these matters be dismissed and he continue to pay as ordered in September.
Court would order that Mr. Babcock would continue to pay his order and will dismiss the actions.
Thank you. Docket 2021-2654 DP involving Brandon Burnett. In this matter, friend of the court spoke with Mr. Burnett, and his right to hearing was waived, requesting this hearing be adjourned approximately 60 days to monitor compliance with payments on his own as he's self-employed, and that he pay as ordered in September.
Court would order that Mr. Burnett would pay his order commencing September, and will adjourn the matter 60 days to monitor his compliance.
Thank you. And then I'll read Ms. Hester's matters into the record. The following matters have waived their rights to a hearing. Docket 2021-3272 DS involving Jaden Jarvis. In this matter, Mr. Jarvis is currently in Calhoun County Jail on other charges. Friend of the court requests that the bond be canceled and he be released forthwith on the FOC charge only, to pay $500 as a lump sum upon release from incarceration. Contact friend of the court within 14 days of release, and today's matter be dismissed.
Okay. Court would order that Mr. Jarvis would make a lump sum payment of $500 upon his release from incarceration from the Calhoun County Jail. That court would cancel his bond, allow him to be released, order that he would contact the front of the court within 14 days of his release from incarceration, and we'll dismiss the action.
You. Docket 2022-1824 DS involving Ian Osborne. Mr. Osborne is also currently in Calhoun County Jail on other charges and has been sentenced to prison. Friend of the court requests that the bond be canceled and he be released forthwith on the FOC charge. Contact friend of the court within 14 days of release and today's matter be dismissed.
Court would order that the bond would be canceled in this matter, allowing the release of Mr. Osborne, that he would in fact contact the front of the court within 14 days of his release from incarceration, and we'll dismiss the action.
Thank you. Docket 2020-2000 DP involving Seth Johnson. Friend of the court's requesting in this matter that we adjourn approximately 90 days to monitor compliance. The $500 bond that was posted be forfeited and applied towards the arrears, and Mr. Johnson pay as ordered beginning in October.
Court would forfeit the bond previously posted by Mr. Johnson, would order that he pay as ordered and adjourn the matter 90 days to monitor his compliance.
Thank you. Docket 2020-747 DS involving Shane Cast. In this matter, friend of the court's requesting the matter be adjourned 90 days to monitor compliance. Mr. Cast make a $56 lump sum payment no later than September 20th, 2024, and begin paying as ordered October 1st.
Court would order that Mr. Cass would make a lump sum payment of $56 no later than September 20, 2024, and we'll adjourn the matter 90 days to monitor his compliance.
Thank you, Judge. That is all I had to read into the record today.
Okay.
All right. I'll bring you back for the hearings. Okay.
Okay.
All right. So,
Almost ready for the hearings.
She
We
has
will
3
have
hearings.
some hearings today.
Oh,
Both
she has
parties
3?
are there.
Yeah, she has 2 with the attorney, 1 without.
Okay, she said she had 2 hearings, so
Well,
she must have missed one.
okay, let's go on to hearing.
And did make a substantial.
Dollars, whichever is greater.
Thank you, and that is all my record matters. 1 hearing today.
1 hearing, okay.
I'll bring you back for that one.
Thank you, Jesus.
All right.
We're skipping them unless they're hot.
Good morning, Ms. Dolph.
Mid, but looks annoying.
You're muted.
Good morning,
Okay.
Good morning, Your Honor. Sorry, having some technical
I
difficulties.
wondered if you were on a roller coaster there. It kept going.
I locked myself out of my computer, so I'm on my phone, so I apologize.
Okay, go ahead when you're ready.
Thank you. First, I'll start with docket 2006-1290 DM William Lambert. The respondent has been making payments towards the arrears on this case. So friend of the court is requesting that he makes a lump sum payment of $100 by September 30th. He continue paying as ordered starting October 1st, and this matter be adjourned to December 18th at 8:45 a.m. to monitor compliance.
Okay. Court would order that Mr. Lambert would make a lump sum payment of $100 no later than September 30, 2024, that he would continue to pay as ordered, and will adjourn the matter to December 18, 2024 at 8:45 a.m. to monitor his continued compliance.
Thank you. Next is docket 2021-1685 DP involving Gary Volk. The respondent did report a new employer, so friend of the court is requesting that he repay arrears at a rate of $50 per month, and this matter be adjourned to November 13th at 8:45 a.m. to monitor the income withholding begins generating payments.
Court would order Mr. Volt would pay his arrearage at a rate of $50 per month, that he continue to pay as ordered, and will adjourn the matter to November 13, 2024 at 8:45 a.m.
Thank you. Next is docket 2003-228 with bonds set pursuant with the statute.
Court would enter a bench warrant for Mr. Payne.
Agree, she's not really hot. She's mid. And I'm skipping her, but this lady's popping in here with hot hair looking like she's coming from bed soon.
And Dia, as a result of his failure to appear on today's date, the court would set his bond in the amount of 25% of the outstanding arrears or $500, whichever is greater.
Thank you. And then I have one more record, Your Honor, for Sergio Villanueva, but I actually have the custodial party here. She's going to Zoom in to be sworn in and potentially forgive some arrears on the case.
Okay.
Bring her in, she's here.
And what is her name?
Erica Ford.
Okay.
Please unmute, ma'am. Ms. Ford. Hello,
Yes,
we're ready to proceed with your case.
okay.
Ms. Ford, we're going to have you raise your right hand, be sworn in, and then we'll ask you some questions.
Okay.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Okay. Ms. Ford, in this matter, you're before the court as you had desired to waive any arrearages owed to you in the front of the court enforcement action. Is that correct?
Correct.
And are you doing this freely and voluntarily?
Freely, yes. Yes, involuntary.
Has anyone threatened you, coerced you, used any undue influence, pressure, or promises to get you to do this?
No.
Okay. And just explain to the court briefly, why do you want to do this?
Because we're actually going through the process right now of getting my daughter's last name changed. She is not Sergio's actual daughter, and he's actually been paying child support for her too. Just because her biological father was giving us a hard time and had things going on his end. So it's been really hard trying to get everybody to cooperate and do what's right.
Okay, thank you. Ms. Toff, is that sufficient to satisfy the front of the court for the waiver?
Yes, it is, Your Honor.
Okay. Ms. Ford, thank you. We'll let you go. You have a wonderful day. And you understand that with these arrearages being waived, you can't go back now and say, well, I want them paid now.
All right.
Okay.
Correct.
Okay, thank you.
All righty. Have a great day.
You too.
And then with that same docket, Your Honor, that was docket 2022-898DS. Front of the court is just requesting that the matter be adjourned to November 27th, 2024 to monitor income withholding for that.
Court would adjourn the matter to November 27, 2024. What time?
8:45 a.m. I'm sorry.
8:45 to continue to monitor the case.
All right. That's all I had for you, Your Honor. Thank you.
Okay, thank you. You have a good day.
Thanks, you too.
Okay, now let's go to the hearing. So let me.
Yes, Jesus, time for the hearings, ladies and gentlemen.
Okay, please unmute everybody. Mr. Ullman, we are ready for your hearing.
Good morning, Mr. Sullivan.
Morning, Your Honor.
It's always great to see you and have you in court.
Thank you.
Okay. Mr. Allman, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges?
Yes, sir, Your Honor.
The court has appointed Mr. Sullivan to represent you. Have you had sufficient opportunity to speak to Mr. Sullivan in preparation for these proceedings?
I believe so, Your Honor.
Okay. And Mr. Sullivan, are you ready to proceed?
Yes, Your Honor.
Okay. Ms. Barrington and Mr. Ullman, I'm going to have you raise your right hands, be sworn in, and then we'll take some testimony.
Okay. Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Yes, sir.
Okay. Ms. Barrington, you can proceed.
Thank you, Your Honor. We are before the court today on one matter, an adjourned enforcement hearing for docket 2022-997DZ, Agency Place Foster Care versus Ronald Lee Ullman Jr. Mr. Ullman's total monthly obligation is $695.50. He is ordered to pay $480 for current support, $212 per month on arrears according to guideline, and $3.50 per month for service and processing fees. His last payment was $53.16 on February 12th of 2024 through income withholding. I've measured his compliance for the past month since the last hearing at $695.50. Mr. Ullman has made no payments. His shortfall at the time of the last hearing was $9,510.84, resulting in a total shortfall of $10,206.34. His total arrears as of August 31st, 2024 were $11,068.53. Mr. Ullman does qualify for food stamps and Medicaid. This action has been adjourned 8 times for a variety of reasons. One of those to submit medical documentation. The medical documentation in front of the court has received from Mr. Ullman indicates that he may continue regular work duty. Mr. Ullman has been involved with the Adult Worker Services Program with Michigan Works since June 17th, 2024. He has not in that time gained employment or made any payments.
Okay. Mr. Sullivan, do you dispute or contest any of the statements made by Ms. Barrington?
No, Your Honor.
Do you have any questions for Ms. Barrington?
I do not.
Any proofs, Mr. Sullivan?
I'd like to make an offer of proof if the court permits, Your Honor.
Go ahead.
I'll start out generally speaking that Mr. Ullman has physical conditions which, contrary to the representation made by the enforcement officer, I'm not challenging what she represented the court as having read, but he indicates to me that he has neuropathy in the feet. He has back issues for which he's going to receive injections tomorrow, and hopefully those will help. But he is not able to carry on a job that requires him to be on his feet, such as working at pork plant in Coldwater, other factory type jobs that require you to be on your feet for essentially the entirety of the shift. The jobs that he would be eligible to work would be jobs that would require him to, or allow him to sit, such as being a bus driver or a truck driver, things of that nature. He does unfortunately have a criminal record and a particular offense that has prevented him from getting a job for which he would be physically qualified to handle. He does indicate to me that this felony conviction, he would be eligible to have it expunged in a year, and that I believe his intent is to pursue that when the timing allows for that to occur. He is in the process of working with an attorney to apply for SSI for his medical conditions. Apparently, he's made application. He's been denied. And he's currently seeking reconsideration. It is, I think the court would agree, it's fairly common to have the SSI application process be just that, a process where there may be initial denials, but eventually the application is accepted and payment is commences. But in any event, his ability to work is limited to jobs in the seated position. He's still continuing to go with Works First to find a job that he would qualify for. He just has not yet done that. He also indicates to me that he turned in paperwork for the forgiveness program. He indicated that he turned it in approximately 2 weeks ago. I understand it's the court system and it's under consideration. So that's another kind of a subchapter of what's going on here that would suggest that maybe the best course of action is to adjourn this to see how the forgiveness program plays out, and also to see if he can get a job through Works First that he would physically qualify for. So thank you very much.
Thank you, Mr. Sullivan. The court obviously has some apprehension about additional adjournment. We've adjourned it 8 times to accommodate Mr. Ullman, so the court's not going to adjourn the matter. Mr. Sullivan, obviously we have medical documentation showing that he doesn't have any restrictions that keep him from working. So I guess I'm just, how does that square with what you've said about him not being able to work?
Well, the difficulty with having these types of hearings is, they're fairly fast paced. I've not been able to see that written documentation. And when the offer of proof was made by a friend of the court, enforcement officer, that's the first I had heard of those documents. So I'm not really in a position to respond to that.
Okay, thank you. Mr. Allman, in this matter, you've obviously been denied your Social Security in this particular case. And what have you done, let's say, so far this year to acquire any employment?
I've actually applied to the bus garage at Penfield. I'll note that my sister is the head director of transportation there. I've applied there, and unfortunately, with the felony that I have on my record at this time, she cannot move forward with my employment there. However, if that were to be removed, I would have a job right now.
Okay. And have you?
And if I had a time machine, I'd be a millionaire, buddy. Julie, thank you so much. It is always a lively chat around here. I love it. And I love you guys for being here. Streamlabs, I have to say, you're on it, baby. I'm proud of you. We're working good together lately. It's almost like Larry Beaver again, back in the old days. Anyways, thank you again, Julie. And I don't know. I don't know what's going on. I don't know what's going on with this guy. What do you guys think? I mean, I don't know. I just don't know.
Have you applied for, have you attempted to have that expunged?
No, due to the fact that when I called and spoke to an attorney about it, because I'm not eligible to have it expunged until 2025, they're saying there's nothing I can do there, that I have to wait till 2025 to have it expunged.
Okay. What's your education background, sir?
High school graduate, some college.
Well, you said you applied for this position at the bus garage. You didn't mention anything else.
I applied for a position at Advanced AutoZone and was denied due to my background check.
Anything else?
Adient, I was denied for Adient as well. I called and I talked to a place called Border Foods. I have a list here. It's just like 33 pages of jobs. And I'll be honest with you, Honor, the first thing I let them know up front when they ask, I let them know that I have a felony on my record, and that pretty much denies me right off the rip, right off the get-go.
Okay.
And these are based off I went up based off your suggestion last time I spoke with you to try to find something that was a sit-down job. And I have been hunting, and like I said, the biggest barrier I have, aside from my back and whatnot, is this felony.
Okay. Anything else that you'd like to tell me, sir?
I just, the forgiveness program is in there. I did do and I believe the paperwork was submitted, but I guess Erica said that it was too old, but I did go through a physician, and I turned that paperwork into you guys to show that what my limitations for jobs was, but I'm not sure if that was ever submitted.
Okay. And you say you're not sure. How could you be made sure of whether that was submitted or not?
I submitted it to the courts, but I don't believe, I think Erica said something that was submitted too late or it was too old to use.
Okay, so you submitted it, but it's there's no utility to it if it's good, it's not filed in an appropriate time. Is that what you're saying?
That I'm not sure, Your Honor. I just know that I submitted it.
Okay. Well, probably a good thing that you follow up on it to check to see.
Yes, sir.
Anything else that you'd like me to be aware of?
No, sir.
Okay. Anything else, Mr. Sullivan?
No, thank you, Your Honor.
Ms. Barrington, was there any, had he been picked up at any point? Was there any credit for any time that he was incarcerated?
You know, he was picked up on a bench warrant back in November of 2023, I believe.
Okay.
Hold on one sec.
John Sullivan looks like he took a wrong turn when he was trying to get to the Law and Order SVU set for his shift today. Does he look like a haggard police detective who's sick and tired of this job, but has to do it because somebody's got to take care of it?
He was booked on November 17th, 2023 and released on November 21st, 2023.
Okay. So he'd be entitled to credit for 4 days. Okay, thank you.
I'll take a look.
Mr. Allman, in this matter, the court will make the following finding. I've heard the testimony in this case. I would note that court has attempted to, in front of the court has attempted to, in fact, accommodate and try to get the matter resolved. It's been adjourned 8 times previously. You would provide medical documentation. That medical documentation shows that you are capable of handling regular employment or regular work, notwithstanding that you have some difficulties, as Mr. Sullivan would say, with your back and foot neuropathy. Your biggest issue appears that you have the felony and you're not able to expunge that at this time. You had applied for Social Security disability, and that was denied in this particular matter. You have a high school education, some college, and in fact, you have an opportunity, if you could get that expungement, to acquire employment. Court does note, based upon what you've testified to, that you have applied in multiple places for employment, but the court does not find that you've exercised due diligence. You failed or refused to comply, and as a result, you are in contempt of court. Anything before sentencing, Mr. Sullivan?
Your Honor, this is not a situation based on the information that's been provided to the court where everything is weighs heavily towards a lengthy period of incarceration. He does have neuropathy. He does have back issues. He does have a felony, which is disabling for employment purposes. So there are several mitigating factors here that would weigh in favor of perhaps suspending jail time and allowing him to find that job that's suited for his situation.
Okay, thank you. Well, in this case, Mr. Allman, you do have in excess of $11,000 in arrearages. Your support obligation is $695.50 per month. So obviously it shows that there's a substantial period of time where you have not paid. The court does believe that that it is appropriate that that the court would have in place some form of incarceration in this matter. What the court's going to do, I could sentence you up to 45 days in jail. I'm not going to do that, but the court does believe sometimes, or the court will sentence you to 14 days with credit for 4 days served. The court would order that you would, in fact, report to the Sheriff's Department no later than September 21, 2024, at the latest at 4:00 p.m. to serve the remaining 10 days. The court would allow you to purge yourself of contempt by paying the sum of $500. So if you're able to pay that, then you don't need to serve the remaining time in jail. Do you have any questions, sir?
Your Honor, I do not.
Okay. I will tell you that if you can't pay the purge amount, you do need to appear on the September 21st date. If you do not, then the court could, in fact, find you in contempt and, in fact, incarcerate you up to 93 days. So
Thank you, Casey Carey. But September 21st is a Saturday, if I'm not mistaken, isn't it? It's a Saturday. Thank you so much, Casey Carey. I am feeling very good because I already went to the gym today. What day is it today? Thursday? That's 6 days in a row. I went to the gym. Maybe 6. Yeah, 6 days in a row. So that's really good. And I feel good. But I'm pretty sure because I just flipped my calendar. It's September. I'm pretty sure the 21st is a Saturday. Just saying. I think that he is on vacation right now, appearing from the Bahamas from his dive class where he will be diving in with turtles soon.
It'd be wise for you to make sure that you show if you can't pay the purge amount. Okay?
Yes, sir.
You're free to go. Have a good day.
Thank you, Your Honor.
Ms. Barrington, is that the only one that you have?
That's it for me. Thank you.
Okay, thank you.
Have a good day.
Yes.
All right, so now let's go to the other ones.
This is why you don't wear orange to court, because when
All right, can you hear us, Ms. Fisher?
Yes, sir.
We're ready for you.
Okay. Ms. Fisher, in this matter, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding and failure to pay child support. This at first offense, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand that?
Yes, sir, I do.
Court has appointed Mr. Sullivan to represent you. Have you had sufficient opportunity to speak to Mr. Sullivan in preparation for this hearing?
Yes, sir, I have.
And Mr. Sullivan, are you ready to proceed?
Yes, Your Honor.
Okay, thank you. Ms. Fisher, I'm gonna have you and Ms. Platic raise your right hands, be sworn in, then we'll take some testimony.
Yep. Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
I do.
Okay. Ms. Platic, you can proceed.
Thank you, Judge. We're here on docket 2016-2741 DP, Randy Fisher versus Marino Flores Jr. Ms. Fisher is here by way of bench warrant. She failed to appear for a show cause before referee Croteau on August 30th of 2024. That would be the third show cause for her. This is the second bench warrant and one prior finding of contempt. Presently, she's ordered to pay $188.50 each month, the result of a uniform child support order from January 9th of 2017. The last payment made in this matter was an involuntary garnishment that we took on March 6th of 2023. That was for $1,485. Prior to that, voluntarily, she last paid in 2019. Compliance was measured over 6 months since her last release from incarceration. During that time, she's made no payments. Current arrearage is sitting at $2,670 through the end of August. She was booked September 10th of 2024, has one previous 21-day jail sentence from February 7th of this year. And at this time, both minor children are still placed through foster care, so that is where money is being distributed.
Okay. Okay, Mr. Sullivan, do you dispute or contest any of the statements made by Ms. Platic?
No, Your Honor.
Do you have any questions for Ms. Platic?
I do not.
Any proofs, Mr. Sullivan?
Offer proof if I may.
Go ahead.
So with Ms. Fisher, there's good news and bad news. And the bad news is that she is in arrears in the amount of $2,670, which is a negative to be sure, but this case opened in 2016. So spread across that period of time, it's one of the smaller arrears that we typically see in these cases. The good news is that she has acknowledged her addiction to drugs. She has applied for the drug treatment court that application is made in connection with a felony offense that's being processed by the court. Was waived, as I understand it. I'm not her attorney in that case, but I understand it was waived yesterday from district to circuit, and she's made application to drug court. And the plan by those involved in her case is to have her accepted into drug court, and as soon as that occurs, her bond in that case would be modified to allow her to go to inpatient treatment, such as Bear River or Sacred Heart. There's a couple of other places that through SWIMBA that allow for inpatient treatment as a condition of bond. And so if her bond is modified to allow for that, and she expects that this application process should take no longer than 2 weeks, that she would then go into inpatient treatment, presumably successfully complete that. She would enter a plea in circuit court, and then at sentencing, she would be allowed to participate in drug court. So that process is really the beginning point of her acquiring the tools to make better decisions in her life, and to not only manage her life, but to provide assistance to her children financially and otherwise. Apparently the two children, age 4 and 6, live with her grandmother, and her goal is to become a part of their life, not just through the payment of child support, but as a mother. So the encouraging news is she's facing her addiction. She's eager to do something about that. And so the future potentially could look bright if she embraces it, as she's represented that she intends to do. So my suggestion is that the court find her in contempt, but give her credit for the time that she served, and perhaps an additional 6 days, which would allow her at that point to be able to be released on bond in the criminal case to attend inpatient treatment. And I say 6 days because if she has a window of no more than 2 weeks to have the drug court application process be reviewed, 6 days would be somewhere in the middle of that time. So she would be eligible to be released inpatient treatment.
Okay. So during that time, Mr. Sullivan, obviously, if the court ordered that she serve an additional 7 days, she'd still be able to go into that treatment. Is that correct?
Yeah, I think that the court could order that she serve an additional 7 days. However, those days would be purged if she's at that point eligible to go into inpatient treatment, or suspended, maybe would be the more appropriate word.
Okay. Okay. Ms. Fisher, obviously, you have this particular problem with this addiction. Have you done anything, let's say, in the last year to acquire employment?
Your Honor, I have tried to acquire employment. I worked a week at Blystall North America. I was also terminated for my drug use from Blystall North America.
Okay. Other than this 1 week where you worked, is there any other employment that you've had in the last year?
No, Your Honor.
Have you applied for any employment in the last year other than this?
I've attempted to apply at McDonald's and Burger King, but I did not show up for my first day.
Okay, so they were going to hire you, but you didn't show up.
Correct.
Okay. How have you supported yourself in the last year?
I have been homeless, and I've been on food stamps. That's the only way I've been able to support myself. I have not been able to pay rent. I'm thankful that I have my parents. That's my home address, but of course I can't do drugs at their house, so I would leave periodically and, well, frequently actually, and I'm lucky that I'm able to go back there, but of course with conditions of no drugs, and
okay,
but that's the only way.
Obviously, drugs are not cheap. How were you able to afford those if you weren't working?
I frequented places that did drugs, just friends. that did drugs.
Probably not the best life choice, I would assume.
No, Your Honor.
Well, anything else, Mr. Sullivan, for the?
No, thank you.
In this matter, the court's heard the testimony as well as the offer of proof in this case that Ms. Fisher does have an addiction that she's been struggling with. And she obviously has some other matters that she's appearing in court, circuit court on. She's seeking to get into drug treatment court in this particular case that she had testified she had opportunity to acquire employment at McDonald's or Burger King. She didn't show up for those particular jobs. Further, she had a job at another place where she was terminated because of her drug use. And as a result, she has not paid any support obligation, but she has, as she has stated, she has had sufficient ability to still acquire her drugs, notwithstanding the fact that she has not paid anything towards support. And it looks like has really exercised very little effort in acquiring employment or preparing herself for employment. As a result, the court will find that she has failed to make a good faith attempt at compliance. She's failed to refuse to comply. And she is in contempt of court in this matter. Anything before sentencing, Mr. Sullivan?
No, just reiterate what I already indicated, Judge.
Well, in this case, what the court will do is, ma'am, you have a prior incarceration.
I didn't think Mikey was in Florida yet. Loud.
Of 21 days, the court could sentence you up to 90 days in this matter. I'm not going to do that. What I'm going to do is I'm going to, here's what I'm going to do. I'm going to sentence you to 45 days with credit for 18 days served. The court will, what I'll do is put a provision in place that will suspend any remaining incarceration provided you go into inpatient treatment through your drug court. So you wouldn't have to serve. You could go into the inpatient treatment, get that done, and the court would suspend the remaining time provided you go into and successfully complete your drug inpatient treatment. Okay?
Yes, sir.
And court would have to put a purge amount in place. I'd put a purge amount in place of $500 where you could purge yourself of contempt, and then you would not have to serve any of the remaining time if that's the case. So anything else, Mr. Sullivan?
No, thank you.
Okay. Ms. Fisher, you're free to go. I hope that you do get your life in order, as apparently it appears that you wish to do. But you're going to have to go follow through with your drug treatment to have any opportunity to do that. Okay.
Thank you, Your Honor.
Thank you. You're free to go.
All right, can you hear us, Mr. Burden?
Yes, I can.
We're ready for you now.
Okay. Mr. Burden, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges?
Yes, I do.
The court has appointed Mr. Sullivan to represent you. Have you had sufficient opportunity to speak to Mr. Sullivan in preparation for this hearing?
Yes, I have.
And Mr. Sullivan, are you ready to proceed?
Yes, Your Honor.
Okay. Mr. Burden, I'll have you raise your right hand and be sworn in. Ms. Platic already previously been sworn.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
I do.
Okay. Ms. Platic, you can proceed.
Thank you, Judge. We're here on docket 2013-2656 DM in the matter of Seeley versus Robert Burden. Mr. Burden is here by way of bench warrant after failing to appear on July 10th of this year for an adjourned show cause before Your Honor. This is the third bench warrant in this matter. He's had 8 previous show causes and 1 finding of contempt. Current obligation is $373.50 each month, working from a uniform child support order from October 28th of 2015. Last payment in this matter would have been the $300 bond forfeiture that applied on June 21st of 2024. Prior to that, the last payment was also an involuntary garnishment in April of 2023. Compliance was measured over 12 months. During that time, he only paid the $300 bond forfeiture. Current arrearage is $6,708.44 through the end of August. He was booked September 6th of 2024, has a previous 21-day jail sentence from August 16th of 2023, and he was previously ordered into the LEAP or the GEMS program, and he failed to participate.
When was the prior incarceration? I didn't.
August 16th of 2023.
Okay. Okay. Mr. Sullivan, do you dispute or contest any of the statements made by Ms. Platic?
No, Your Honor.
Have any questions for Ms. Platic?
I do not.
Okay. Any proofs, Mr. Sullivan?
Offer proof if I may.
Go ahead.
So there's a few pieces of information I'd like to share. One is one of the areas of concern for Mr. Burden is that there's one child, she's age 14. He hasn't seen her in 5 years. He's been denied parenting time. I did spend some time explaining to him the process by which the court can order a specific parenting time schedule. As I understand in speaking with him, it sounded to me like whatever court orders were in place in terms of custody / parenting time, I believe that the parenting time section simply said that the parenting time shall be as the parties may mutually agree without a specific schedule. So I did educate him on what processes, do it yourself and otherwise, are available to get that corrected. So he has a specific schedule. That aside, he unfortunately does not have any money to pay up front at this point in terms of negotiating a settlement with some upfront payment of child support. His last job for which income withholding took place was at Livonia Tool, and that was in 2023. He does live in Teconcha, so he's had transportation issues. For example, he's had a couple of jobs at the pork plant in Coldwater, and unfortunately lost those because in both cases he had transportation breakdowns, and they just weren't able to keep him on with missing work. I believe that he has 12 or 13 days credit for the time that he has spent in jail. I think he's been in jail since 9/6/24, so he would have some credit coming that way should the court find him in contempt. What I would ask is that the court sentence him to not more than 25 days credit for time served, and of course he would get good time off the 25 days would be my understanding, and that would be a sufficient sanction for the situation that he finds himself in.
Okay. Thank you, Mr. Sullivan. Mr. Burden, you apparently have lived in Teconcha and you had a job in Coldwater. Obviously, you had transportation issues. You lost that. Why did you not move to Coldwater where you could get to your employment easier?
I mean, I would love to, but I simply can't afford to go just up and move someplace. I mean, you need to have a down payment, you need to have like all that stuff. So I can't really just up and move, any place I would like to, as much as I would love to. It's just not that simple, unfortunately.
Are you paying for the current place that you're
I'm staying with my mom out in a camper. I'm staying at my mom's house out in a camper.
Okay. Okay. You had an opportunity previously to participate in the GEMS program, which you didn't show up to. Why was that?
I did show up. I did go to the Michigan Works.
So I agree that first of all, these are not first time offenders. They have so many programs for most of these people to participate in. It is almost willful when you're this delinquent on your child support. Just being honest. Like they have lists of people to give you fucking jobs, all these different things. That's why the excuse counter gets racked up so high around here and it's so funny because for the reality is like if one of them went out and got the most minimum wage job there was and worked it 40 hours a week or whatever and the company will pay them like gas money, not the company, the government. There's programs that'll pay people gas money, pay them for going to work, all those different kinds of things. They want to do it. They do want them to be supporting the child. But he could also then apply to have it reduced to the bare minimum because has a history of that income, and they would help him do that. But yeah, that's a little bit of a.
We're in Coldwater, and I applied. I did everything I was supposed to, filled out all the stuff on the computer, and I just never heard anything in regards to it. So I didn't know when to show up. I didn't know what to do.
Well, did you ever call them back and try to find out what you had to do?
Yes, I did, and I just kept hearing that they would contact me and they'll be in contact with me, and I've never heard nothing back from them.
Okay.
And when I went there for to fill out everything. I was in person the first time, and then I did call back to follow up with it.
What is your education background, sir?
I'm a graduated high school.
And do you have any physical, mental disabilities or infirmities that keep you from working?
No, I do not.
And so the only thing that's keeping you from working at this point, it sounds like, is your transportation issue.
Yes, the transportation issue. It's hard.
How have you supported yourself in the last year if you're not, if you don't have any income?
I've pretty much been living with my mom, and my mom's been helping me out the best she can. She has Social Security, and it's been rough. It's not been an easy journey at all. It's been tough. It's something I'm not proud of. I'm really not proud of it. I want to get a job. I need help. Like I don't know what to do. I'm at a loss. It's horrible. It's degrading.
Well, tell me, what are you going to do different next month that you're doing now that would change things or provide the court with any confidence that you're going to comply with the orders of the court?
The only thing I have left to do is pretty much walk. I mean, if I have to walk, I will walk. I mean, I do want a job. I do need a job. Like my life is pretty much depending on me getting a job. It's not like I don't want to work because I do. It's very difficult with my background getting a job, and life has just not been easy. And I mean, if I have to walk, I'll walk. I mean,
okay,
I pretty much feel like I'm, huh?
Children in Africa carrying water miles a day and then walking to school. Like, you don't have anything else to do, bro. You don't have a job. You get a bike, and then you get a scooter, and then you get a fucking moped, and then you fucking deal with it. That's how you do it, bro. Like, if you don't want to walk, get a bike. Believe me. Believe me.
You said that you've had difficulty because of your background. What is that?
I do have, a prior drug charge on there. I don't have any felonies, they're all misdemeanors. I do have a prior drug charge, and I do have an assault that happened back in like 2017, I believe it was. I mean, and it feels like, even though they're misdemeanors, I feel like they're treating them as their felonies. I mean, I don't know. I've been applied and I've been rejected because of that.
Okay. Let's say this year, from January to the current time, how many places have you applied for employment?
When was that time frame?
It's January to the current date of your incarceration.
I would say on a daily basis, I am applying at least 30 to 40 jobs on a daily basis. I do have my application out on the internet. I do have, I have been applying.
I assume most of these 30 or 40 you say they're basically online.
Yes, yes.
Okay.
Yes, that is the easiest.
Have you had any interviews?
I've had, yes, I have had some interviews, and I just have not heard anything back from them, the current interviews that I've had.
Okay, have you called the places that gave you interviews? Have you called them back to check on?
Yes, and I just keep hearing that my application will be under review and they will be contacted.
Okay.
I have been trying. I mean, I feel it's degrading to me as a man and as a father to not have a job and not support my child. Like I do want you guys to know I do understand.
Okay. Anything else you'd like to tell me, sir?
No, sir.
Anything else, Mr. Sullivan? Mr. Sullivan?
No, thank you. Yeah,
okay.
No, thank you.
Okay. Court has heard the testimony in this matter. That's heard from the front of the court that we have a situation where we have an arrears owed in this case in the amount of $6,708.41. That's substantial arrears when you consider that his monthly obligation is $373.50. That again, in this matter, we haven't had a voluntary payment in quite some time. There was a bond forfeiture back in 2024, as well as a garnishment occurring back in April 2023, and that Mr. Burden was referred to the GEMS program previously. The front of the court has stated that he did not show. He claims that he did show to Michigan Works down in Coldwater, and that again, it was not taken any further in this particular matter. He states that his biggest problem is transportation, and that he did have employment available to him, but he did not have transportation, so he lost that employment, and that he's simply been, I guess you'd say he's been existing based on the generosity of his mother and her assistance, and that he claims that he wants to work in this matter, but it doesn't appear to the court that he is taking much action.
Are you on your 5-star vacation already, demanding things from the people working in front of you, Mikey? What a wonderful insight you showed us earlier in members only. I was intrigued, to say the least. Everybody here is talking about what they're going to do while you are gone. You will be sorely missed, but we'll figure out a few things. I think we'll help ease the pain a little bit. Anyways, this guy is wishing that we could restart life at this point so that he could go back and make some different choices.
Action to prepare himself for employment, as he is located out in Teconcha, which is pretty isolated from, any place of employment, etc. The court will find he has made number of applications online. He claims that he has followed up with that, but that basically to no avail. So court notes that he is well aware of his support obligation. He's failed to refuse to comply and pay that, notwithstanding him having no physical, mental disabilities, whatever. He has a high school education, so he's capable of employment, but he's not placed himself in a position where he could acquire employment. Again, self-isolating, but somewhat of maybe necessity, as he has no other place, but he's not, again, prepared himself to acquire employment. So the court will find that he is in contempt of court. Anything before sentencing, Mr. Sullivan?
Not beyond what I've already indicated in terms of the 25 days, Judge.
Okay. Well, he has a prior 21-day incarceration back in 2023. Mr. Burden, the court could sentence you up to 90 days in jail. I'm not going to do that, but I do believe that, again, some period of additional incarceration is appropriate to maybe impress that you've got to do more than what you've done in the past. What I'm going to do at this point, I'm going to sentence you to 45 days in jail with credit for 12 days served in this matter. The court is going to allow you to purge yourself of contempt by paying the sum of $750. If you're able to pay that, you wouldn't have to serve the remaining time. Do you have any questions, Mr. Burden?
No, I do not.
Okay, thank you. You're free to go. Have a good day. And Mr. Sullivan, I don't know, is that the last one we have for you?
I think that's it.
Okay. Mr. Sullivan, thank you as always for giving your assistance in this matter. It's always, we always enjoy having you in court.
All right. Thank you very much, Your Honor.
Thanks
Right
for
back at
reporting
you.
in here
Bye,
from
John.
Law and
Thank you,
Order.
John.
Bye-bye.
Okay, we have one more hearing now without the attorney. Let me get these two in
Oh, sweet.
here.
One hearing
Both
without
the
an
custodial and
attorney.
non-custodial.
Ms. Platic, you're always, you're
I
keeping
know.
us busy today.
I know.
Oh my God, this guy's appearing from vacation too, Mikey. Let me just say, don't ruin your vacations worrying about us back home. Proverbially. The internet home, you know what I'm talking about. Anyways, the whole point is vacations are needed, warranted, and allowed. We don't vacation shame around here. So nobody would blame you if you didn't. But, and of course, yes, I'll take care of everybody. Next week. Seriously though, what is with this angle for his camper? And of course, I joke, but Mikey has, I'm sure, many premieres that'll be happening next week, regardless of him and Creed being off. Let's be realistic. They're going on vacation together. Everybody knows it. That's how it works. But half and half. Half the time in Tennessee, half the time in Florida. They were just fooling us all. But just like hand in hand together, enjoying their time. But yeah, you deserve a vacation. That's right. Anyways, I'm forgetting what I'm talking about. This guy though, frolicking in the meadows and the swamps. I love vacation. I'm Canadian. We love vacation. We vacation all the time. You travel anywhere in the world, and I almost guarantee you, you'll find a Canadian there.
Okay.
And who is the respondent, Ms. Platic?
Mr. Frazier is the
Okay.
respondent.
Wasn't sure. I had just the name. Mr. Frazier, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges?
Yes, sir.
Court will advise you have a right to an attorney. The court would appoint an attorney to represent you should you desire an attorney. It's my understanding you wish to proceed without an attorney. Is that correct?
Yes, sir.
Are you doing so freely and voluntarily?
Yes, sir.
Has anyone threatened you, coerced you, used any undue influence, pressure, or promises to get you to appear without an attorney?
No, sir.
Okay. Court will find that Mr. Frazier does freely and voluntarily waive his right to an attorney. Mr. Frazier, I'm going to have you, and Ms. Suter, I'll have you as well raise your right hands, and we'll have you sworn in, and we'll take some testimony.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Okay. Just for your information, Mr. Frazier, Ms. Platic has previously been sworn in, so you can put your hand down now. Ms. Platic, you can proceed.
Thank you, Judge. We're here on docket 2020-2441 DS in the matter of Suter versus Lewis Frazier. Mr. Frazier is here for an adjourned show cause hearing. He was before your honor on July 10th of 2024. At that time, you sentenced him to 14 days in Calhoun County Jail with credit for 0 days served. That sentence was suspended pending his compliance with monthly payments. At this time, compliance was measured over 2 months. During that time, he should have paid $538.50 each month. In the month of July, he paid $300. In the month of August, he paid $970. If you total those two amounts up and compare them to the total amount that should have been paid, he overpaid by about $193. Arrears as of the end of last month are sitting at $13,773.96. I believe that's all the updates I have for this one. No other changes to the orders. And Mr. Frazier also indicates that he has the money available to make his payment for the September obligation as well.
Okay. Ms. Platic, just to clarify then, we suspended the time so he'd make monthly payments. He's made the monthly payments. So
right.
Why are we back here if he's
To
making
note,
payments?
at this point in time, this is the first time he's been consistently compliant. So friend of the court is neither here nor there on whether to continue the sentence, dismiss it. I'm a little hesitant to completely take him off judge's schedule. Because this is the best he's been doing since we've had him on your schedule.
Okay. Well, Mr. Frazier, the court does note that you have complied. In fact, you made overpayment by $193. So the court appreciates that. And I guess I'll ask Ms. Suter. Ms. Suter, you have to unmute. Is there anything you'd like to say to the court in this matter?
No, Your Honor.
Okay. You have been getting the payments though?
Yes, I have, Your Honor.
Okay. Mr. Frazier, what I'm going to do is I'm going to continue the suspension of your sentence in this matter as long as you continue to make the monthly payments, with the provision that, again, Ms. Platic can bring the matter back if you fail to make any of the monthly payments. So as long as you make your payments, you're going to be able to stay out of jail. If you miss a payment or something like that, Ms. Platic will bring you back in, and you're going to have to.
I'm going to continue to do the payments, but am I going to have another Zoom meeting?
You may, I don't know. It's a matter of if you make your payments, you won't have to be back. If you don't make your payments, then the court will bring you back in, and we'll look at whether you serve that time or some additional time.
Yes, sir.
So continue.
I'm sorry. How do I go about because working on the road, I don't get my weekend rights. How would I go about getting video rights at least while I'm on the road working? So that way
you'll have to file a petition in the underlying action to acquire some sort of pairing time, whether it's through a video, whether it's through phone calls or something of that nature. But you're going to have to initiate that. You can do it on your own. You can go to the circuit court clerk's office. They will give you the improper motion packet. You'll fill that out, and then you'll have to schedule a hearing.
All right.
Okay.
Yes, sir.
And then what happened at that point? Ms. Platic, you had a question?
I just wanted to clarify, so for today, we're dismissing on the premise that he continue to pay as ordered and that the next hearing would be back before your honor.
That's correct. If in fact he misses a payment, then I do want the matter brought back in and we will address it at that time.
Okay, perfect.
Okay. Thank you. And Mr. Frazier, you've shown obviously effort in taking care of this. We hope that you continue to do so. And I'm sure you do, so you don't end up having to go back to jail, okay?
I understand that, sir. It's more about just being able to see her. I figure if I do my, monetary duties, that'll look better when I do the pro-op. So
Well, and in fact, they're mutually independent, so that one's not, if you're not getting parenting time, that doesn't mean you don't have to pay. You can file the motion and enforce any amount of contact, et cetera. So that's up to you as to what you do.
yes, sir.
Thank you. Ms.
Thank
Suter,
you.
anything else you have?
I mean, he's had opportunities to have his parenting time, but he's seen her a total of 21 hours in the last 4 years. So,
Okay. Well, he's going to have to file that petition and then we'll address that at a hearing on that matter.
okay, absolutely.
Okay? Okay. Thank you. You're all
Thank
free to
you.
go. Have a good day.
See you.
You too.
God bless, brother.
Thank you.
What brother? The judge said thank you. God bless, brother. Ew, brother. What's that, brother? What's that? Ew. I don't know why I found that so fucking funny and cringy. So cringy. Oh, back in my living room. I'm so proud of myself for already having gone to the gym today. I already did it. I'm so proud. It's amazing. Oh. What are you guys gonna have for dinner? Or probably most of you have eaten. I'm a real late eater. 8-liter? I'm an 8-liter late eater. That's a Canadian version of that. I don't have vacation next week. Not all of us have that luxury, but I will be around, so don't you worry. If you're needing a fix, a family fix, but like online family, not your weird uncle. You know what I'm saying? Also, I think I might do some cooking videos. I may have figured out a way to set that up, so keep an eye out for that coming up. I hope that you guys have a wonderful rest of your night. I don't know that Jesus God. I don't know that there's anywhere else to send you, but I will say to you that I love you, I'm proud of you, and I will see you in the next video. Bye.
Ways down and ready to ride.